But I guess where most of the attention when it comes to Section 3 has been focused is on this savings clause, that you have this obligation subject to any statutory provision. So the question is, should that be literally interpreted to say that if an organ of the state is doing something for which it has legal authority, so it's acting under a piece of legislation like the Housing Act, for example, ought that to be sufficient to save their actions from a Section 3 breach, even if those actions are non-convention compliant? Or should we interpret the savings clause in an expansive way that requires organs of the state not just to act under lawful authority, as they always have to do anyway, but to assess which of the potential avenues for action available to them is the least violatory of the convention, and to select that one? That expansive approach is the one that stands now after PILA. Whether it will stand or not after the Supreme Court decision in Gallagher, which I am pretty sure hasn't been handed down yet, even though I think it was argued this spring, we have to wait and see. But there are pros and cons of both. If you want to look at it from a purely rights protection perspective, then the expansive, the least violation approach is clearly better, right? But if you want to look at it from what the Act actually requires, then the literal interpretation is better. Because unlike in the UK, where they build in those avenues, there is nothing less violatory that you can do. The provision can't be interpreted in a convention compliant way. The authority has no option. These are the savings built in to the UK Act. Our saving is bald, subject to any statutory provision. So I have no objection to an expansive approach, but it would be one that was really quite progressive, because it's not what Section 3 requires. And that question around the savings clause will hopefully be answered in the Gallagher appeal, and that will make things much clearer then. So that's Section 2 and Section 3. The two sections where I think, in fact, all of the potential for the ECHR Act really bringing the convention and its ideas and its provisions into proper life in Ireland lies. So what about the Declaration of Incompatibility in Section 5? I am not hugely convinced that this is of any real use whatsoever. In the paper I describe it as similar to a cubic zirconia engagement ring. It is shiny, splendid looking and attractive, but practically worthless apart from the sentimental value. I mean, cubic zirconia is lovely, but is that really what you want? Or do you want the diamond? Or do you want neither? Do you want something more effective, like an actual commitment, like a Section 2 or Section 3 a case or claim that succeeds? The Declaration of Incompatibility makes perfect sense in the context of the Human Rights Act. It doesn't, I think, make sense in the context of the ECHR Act of 2003. It is a remedy of last resort, which is an implicit acknowledgement that really the remedial potential lies in Sections 2 and 3. It is also a remedy that doesn't effectively change the position that the applicant is in. The law remains in force. The next time the law is being applied, the next person has to apply for another declaration of incompatibility, and even if you get a declaration of incompatibility, the law that you're complaining about can still be applied to you. So you have no real remedy in the real sense of the word. You might get an ex gratia damages payment, which might be useful, and in some circumstances, the communicative power of the Declaration of Incompatibility, which I do not intend to denigrate and is important, that might be particularly important in things like strategic litigation. But if you're talking about somebody whose heating has been turned off or who's about to be turfed out of their home, a Declaration of Incompatibility doesn't do much for them from an effective perspective. And so for that reason, I think that's part of the reason why the European Court of Human Rights has expressed the view that a Declaration of Incompatibility under the ECHR Act would not be a remedy or has implied that it would not be an effective remedy under the Convention. They did that in A, B and C and Ireland, where the government argued that the applicant's failure to get a declaration of incompatibility meant that they had not exhausted all domestic remedies, and the European Court of Human Rights said that this was not an effective domestic remedy and therefore they were not obliged to exhaust it. So very pretty magpie type provision, but I don't think it has much real potential apart from its political potential. And even that is dependent entirely on something that has been in very short supply, and that is political will to act on the basis of a declaration. So in contrast again with the UK, where it has now become de rigueur, even in counter-terrorism cases, for the government to change the law in response to a declaration of incompatibility, we don't seem to have quite the same approach here. How much time do I have left, Larry? Oh, you don't know. I think I've about 5 minutes left. Should be enough. So if all the action is in sections 2 and 3, then there's one remaining thing for us to think very briefly about, and that is the role that the Convention itself, and particularly the decisions of the European Court of Human Rights and other bodies adjudicating under the Convention, have in domestic litigation. This is treated of by section 4 of the Act. It's reproduced there on page 9. It's very long, I'm not going to read it. But what is very clear about section 4 is that it does not make decisions of the European Court of Human Rights binding in domestic law. If Ireland is a respondent, they are binding in international law, and there is an enforcement mechanism there within the Council of Europe for that bindingness, if you want to call it that, to be exercised. But they're not binding in domestic law under section 4, nor I think should they be. The first reason is blindingly obvious, and that is it would be unconstitutional to bind our apex court, our superior courts, to a decision of an international court without a constitutional convention, referendum and amendment to that effect. And the second reason is that it doesn't make sense within the scheme of the Convention itself.